Apple penalized 1.8 billion euros, that's about $2 billion, by the European Union for violating its competition regulations. The EU declared that it was going to punish Apple, the US tech giant, for the first time ever for violating antitrust laws by keeping competitors like Spotify from informing iPhone customers that they could subscribe to the services for less money outside of Apple's App Store. Wednesday this week, French authorities announced that Google will be fined 250 million euros for violating their agreements to compensate media businesses for online content replication and for utilizing their content for its AI chatbot without notifying them. As per its agreements, news organizations must get a clear offer of reimbursement from the US internet giant within 3 months of filing a copyright complaint. However, the regulator announced that Google will be subject to the increased penalties for not engaging in, quote, good faith negotiations with news publishers and for failing to respect commitments made since 2022. Apple, again, they've been accused and sued for what is said to be illegally controlling the smartphone industry by the U.S. Justice Department and over a dozen states in a massive antitrust case that was launched against the corporation. The U.S. government is cracking down on the huge sector whose dominance has gone mostly unchecked over the last few decades, and this is the largest in a recent run of big tech businesses to face antitrust allegations. Here's an excerpt of a press conference that featured U.S. Attorney General Merrick Garland.
We allege that Apple has employed a strategy that relies on exclusionary, anti-competitive conduct that hurts both consumers and developers. For consumers, that has meant fewer choices, higher prices and fees, lower quality smartphones, apps, and accessories, and less innovation from Apple and its competitors. For developers, that has meant being forced to play by rules that insulate Apple from competition. And as outlined in our complaint, we allege that Apple has consolidated its monopoly power, not by making its own products better, but by making other products
worse. Now, let's take a look at Apple's response. They did put out a statement in response to this lawsuit that's been brought forward by the U.S. Department of Justice. Apple said in their response, this lawsuit threatens who we are and the principles that set Apple products apart in fiercely competitive markets. If successful, it would hinder our ability to create the kind of technology people expect from Apple, where hardware, software, and services intersect. It continued in this statement with respect to what what would happen if the law actually goes through. And yeah, so we'll get that the rest of that. Okay, yeah, so here it is. We have the rest of that statement now from Apple. Here they said it would also, that's the lawsuit if it's successful, it would also set a dangerous precedent, empowering government to take a heavy hand in designing people's technology. We believe this lawsuit is wrong on the facts and the law, and we will vigorously defend against it. So we've got another lawyer. Well, I said another lawyer. Actually, the first guest was a professor, but they're both authors. We have another author. That's what I meant to say. We're joined by Seye Ayinla, who is the partner at Duale, Ovia Alex-Adedipe, and head of competition law and merger control. He's also the author of the book Nigerian Merger Control: Principles and Practice. You're very welcome. Good morning to you.
Thanks for having me.
So I guess if we could start with Apple and the U.S. Department of Justice, if you can break down what's at play here.
So, let's take it like this. Let's paint a hypothetical situation. So I'm a company, I have a port and I have a shipping line. So I'm vertically integrated, very efficient. I can actually sim the shipping line with my port, so it's quite easy. Now imagine you are my competitor, but not because you have a port, but because you have a competing shipping line, right? So two things. Whilst I have a monopoly in the port business, which is the upstream, we can call it, but I face competition from you in the downstream, which is the shipping business. Now, what can I do? I can do two things. I can either say, you know what, I won't grant you access to my port. And let's say the next port is some kilometers in another state from here, right? Which means your cost of doing business has gone way up, right? Or two, I can say, okay, I'll grant you access to my port, but I'll give you the smallest part where you can't function efficiently. What I've now done is I've leveraged market power I have in my port business to actually stifle competition in the shipping business, and I've raised your cost. So in typical, they call it foreclosure. When I say no, that's a complete foreclosure. When I say partial, when I say yes, you can use some parts, That's a partial foreclosure. Now let's bring it down to where we are now, which is the tech business. Now the way tech has operated, they operate like network, right? I have one core product, so I have my operating system. But what I've been able to do is I've been able to build a lot of adjacent markets around it, right? So I have my payment platform, my streaming platform, name different products around it, and it all comes into one thing. Now, it's good for the consumer because on one platform, I can get as much products as possible. But then again, the way the network operates is that it has to interoperate. So imagine just using, if I have a Glow line, I can only call Glow, but I need to be able to reach people in the other, on the other network. Yeah. Same way. There will be competing firms who will do similar niche products. So whilst you may not be able, right, to actually compete with me in terms of the OS, my operating system, but you may be able, right, to now compete in some niche areas like music streaming, payment platform, and all whatnot. So what they're basically saying is that Apple is trying to foreclose competition to stop development of better and more innovative products, so they can't actually compete with those other products of Apple. Now, when Apple comes up with that statement that it's going to kill competition, or not kill competition, but make them not innovate, and that's who they are, that's very logical, because the thing about competition law is you need to strike the balance between static efficiency, how well are the consumers getting the best, or also dynamic, the innovation, the incentive to create more. But I'm not too sure that defense will fly, because other tech giants have raised that defense in the past, and it wasn't successful.
Okay, I want to give you a response, because this is being debated everywhere. This was on NBC. There was an internet lawyer from, I think it's George Mason University in Fairfax, Virginia. He outright said the law doesn't make sense. I want to get your thoughts on what he said.
Absolutely. Look, this is March Madness. This is a baseless claim predicated on the simple fact that consumers are not being harmed. Now, my colleague over there was saying how the devices have not continued to improve. That just doesn't match reality. It seems like every other day I'm getting some new function or feature pushed to my phone by Apple as part of an iOS update. They are constantly innovating. Let's look at competition in the marketplace. There's Apple and there's Android. So you have the Department of Justice that is actually suing Google, the maker of Android, for being a, quote, monopoly, and now suing Apple for being, quote, a monopoly, yet they're direct competitors. So you got to pick one. Which is it? And finally, we have to look at what is the purpose behind this. The complaint is, well, iPhones are really expensive. Yeah, they are. That's accurate. But the thing is, if people don't want to pay a premium price for a premium product, they can always go out and buy an Android phone or another different device. And that's competition in the marketplace. It's like complaining that Sonos speakers are too expensive. Yeah, they're expensive. They're a premium product. But at the end of the day, the claims in this lawsuit just don't make sense.
I mean, there seems to be this widening classism gap between iOS users and Android. But what do you make of his comments?
Right, so the comment, it's correct and also to an extent incorrect.
Okay.
And I'll say this. First of all, he is right that yes, there's been innovation, new updates on new features to the phone. That's correct. But you cannot say categorically the other competitor who's bringing other features may not be as good as yours or may even be better than yours. Right. So, for example, let's take what happened to Microsoft some years back, or over a decade ago, right? So you had the dominant operating system for PCs, that was the Microsoft Windows, right? Now they also started providing you with the operating system bundled with their Windows Media Player, and then the EU Commission takes them to court, says, look, what you're doing is you're bundling two things, right? That's totally anti-competitive, right? And what they had come to say was that, look, first of all, innovation is what we do. We spend a lot of money on research and development, and they raised a valid argument to the fact that the way the economies of scale in with tech it's so mad. So you have your fixed costs are very high, but your marginal costs are almost near zero, right? So we invest a lot in all this. But then again, there was evidence to the fact that there were other media players that actually had better functionality than Windows Media Player, right? So what you've basically done is you've been able to shut people that had better media player to you can given the fact 90% of PC users were actually on the Microsoft Windows. So you've been able to shut those guys out, right? And they actually said, look, people wanted some things without Windows Media Player. For example, I may not want your Windows Media Player, but the fact you have your Windows Media Player on your OS, automatically many consumers have an inertia to trying another thing. So that's that. And what they told them to do was, look, stop bundling it, give us an operating system without the Windows Media Player and another one with the Windows Media Player. And what had happened is there were actually evidence there were better Windows Media Player infrastructure
than
out
Windows.
there.
Yeah.
And so same thing, you might be correct to say that, yes, you're innovating, but then again, there could be better innovative products.
And you're not giving them a chance to see those products.
Exactly.
Thank you so much for the breakdown. Let me get to the France and the 250 million euro fine on Google for not paying content, media outlets for their content. What do you make of that whole law? I think is it fair that internet tech giants should be paying media outlets for their?
All right. So this is where you have not supposed a clash or an interaction between two areas of law who want to protect consumers but using different routes. So you have copyright, right? Who wants to make sure authors are incentivized to keep producing, but then again they have to give them some monopoly rights over their product. And you also have competition law who wants to make sure that the products are available now and everybody is getting benefits. Now, the truth of the matter is print, as the digital market gets bigger, right? People now access news, access content on the go rather than getting the normal way of getting the news, right? So majority of the time, it actually goes online. And if the Google has the algorithm to actually scrape and get a lot of content, harmonize it, that is the author's right? And copyright is a place that is a field of law that has been around for centuries, trying to protect the right of authors who create, who write, and who actually exercise their mind to create some certain things. Now, being able to just bring them, and the way copyright is, those products are non-rivalrous. My use doesn't affect your use, right? Your use doesn't affect another person's use. And if you churn out those things in huge chunks, my incentive to keep writing, right, is something else which we need to debate about, right? So not actually going with them, and they had actually made a commitment that we will pay, we'll get remuneration paid to them, which is a normal thing about copyright. You need to incentivize them. So how do we balance two? One, to incentivize the people to keep creating, like Google, and how do you also incentivize authors to keep writing and pushing out content on the internet?
Gotcha. I guess just a few minutes to go. Our first guest, we were talking to a professor in the Netherlands about the European Union's Artificial Intelligence Act. And of course, we've got France fining Google 250 million euros. We've got Apple also being hit with 1.8. Do you think Europe is more stringent and more strict about holding the feet of these tech giants to the fire than your North America, Asia, and so on?
Totally, I'll agree with that.
Yeah.
And so if I take it historically, let's just copyright, for example, right? Historically, America used to be the one quite advanced. So, for example, the idea of the fact that you could download, you could video on demand, music on demand, had been contemplated by the United States way before the copyright, before they had the Digital Millennium Copyright Act. That has been way before, right? But then again, the principle is, the normal thing is law always has to catch up with technology. That's been it. But one thing that was good about the US is they were quite advanced. But what had happened over the last couple of years, particularly with the GDPR one, they laid the tone where the whole world follows, right? Yeah. Now with the AI, right, that is another trend we actually see. Now, so for example, what the DOJ is taking Apple to court for in the US, right, would have been something you could have called maybe a straightforward case in the EU, because they had the Digital Market Act that basically says, okay, there's some category of platforms which are called gatekeepers. And last September, Meta, Facebook, Meta, Amazon, and also Apple was characterized as gatekeepers. Yeah. And one of the things they were supposed to do is not to prevent interoperability between different niche products. So that would have been the case of them brought under the Digital Market Act, under the EU law, but under the US law, it's more of just using our normal case laws and trying to actually take Apple to court and get the judgment. And this has been going on for quite a number of years, and I don't see it's actually subsiding anytime, because the argument is that the traditional tools of competition law are there actually enough to cater to the challenges of the digital market. And this will be an ongoing debate for quite some time.
Have these tech companies, have they gotten too big? Have they gotten so big to the point to where, because some say that they're being punished for their success, while others say the regulation is necessary. How do you see this?
Sure. There's a theory called the Gale of Creative Destruction, which basically means by an economist in the early 1900s, right? So what he says is that the way the market is that the particular network market is competition for the market, not competition in the market. So for example, you are competing with me selling this laptop, right? But because our market is characterized by a lot of innovation, right, which is fast, what we'll find is that somebody dominates the market for a particular point in time. I'm not sure if you play games. Back when I was growing up, it was all about NES, right?
And then Super Nintendo, Sega Genesis.
Back then we used to use our lunch money to actually go play those games. Or I know of guys actually went to take it just to play here, right?
Yeah.
And there was a time when the UK Competition Authority said, in 1 year, said SNES, Nintendo had a monopoly. But that same year, there was, I think, the PlayStation by Sony. The next year was Xbox by Microsoft. And now NES is just completely gone, right? So clearly, the more they innovate, there'll be better, there'll be bigger challenges. But then again, the practices like what Apple has done is what they've been able to perpetrate themselves and to make sure that gale of creative destruction never takes them out. They acquire small startups which can eventually become head-to-head competitors with them, and also things like the foreclosure, trying to make sure that your product doesn't interact seamlessly with mine within my own ecosystem. So the issue is, are we talking about competition within a particular platform versus another platform, right? And at some point, one standard will override, or is it just one platform where the competition operates within different niche products and against the major player in that particular platform?
Awesome. I admire you folks in the legal field. You cover just like economics, you cover the business of medicine, entertainment, technology, sports, the legal field is there. Seye Ayinla, the partner at Duale, Ovia Alex-Adedipe, also head of competition law and merger control, and the author of the book, Nigerian Merger Control Principles and Practice. Thank you so much for joining us.
Thanks a lot for having me.
Robust discussion. Appreciate your time.
Thank you.